you with regards to procedurally, we're based on the remedy or the relief, deny it, outright issue an order to show cause, the burden shift. In effect, we get into, do you then get into the more factual, which we've previewed some of the more factual disputes, but right now the issue is whether it's sufficiently legally factually pleaded. And so I want to focus just on that. And so what is your position with regards to regarding the four corners of the document? What is missing regarding the pleading that would establish otherwise a requirement, a mandate that the client is not otherwise performing, that this court should direct him to do?
Counsel stood up there and argued and conceded on the record that he believes Mr. Shipp is arbitrarily exercising his judgment. That is not a ministerial duty. So they have not identified the outright duty of compelling performance of a duty. They are litigating entitlement to access to the AGG system and all the cases that were handed to the court that are pleaded in the motion to dismiss, City of Bradenton, State XL Board of County Commissioners, Miami-Dade County Board of County Commissioners. Those cases stand for the proposition that entitlement is not what we argue in a writ. So they have not identified the ministerial duty. That's defined in 112.312, paragraph 17. It means action that a person takes in a prescribed manner in obedience to a mandate of legal authority without the exercise of the person's own judgment or discretion as to the propriety of the action taken. This court, if it's going to order Mr. Shipp, or it feels it's facially sufficient, it's going to have to identify what the express statutory or regulatory duty is that he's not complying with. So I think the example used in the motion to dismiss was he has a duty to issue marriage licenses. If he chooses to not issue one because he thinks these people are going to make a bad couple, he's not exercising his ministerial duty, to which discretion is not allowed. He can be ordered to issue that marriage license. They keep talking about the Board of County Commissioners' duty to do something, and as part of their duty, you can order him to do something. That's the opposite of the standard of a writ. The writ has to show what clear function of duty is he not performing, to which they have a correlative duty coming off of. It's not the other way around, and he conceded that in his response to the court.
So in terms of their position of what's actually happening, but also, if there's not an issue with what is pled, which is under the statutory framework, they have the authority to either by default allow the clerk, in this case, it's written out by default, let's say by resolution, had the clerk become budget officer and has been that way for about 4 decades, but now has shifted into exercise of the decision to have an actual identified county budget officer outside of the clerk's responsibilities. Then if you read the entire legislative enactment, each of the pieces of it, and of course obligated to give meaning to each of the pieces, that when the county, which has the authority to shift from the clerk being the county budget officer to having someone else be the county budget officer, why should it not be read in paramateria with each other, the legislative scheme, if you will, that the clerk, who once was in that capacity, has to facilitate access to the records that are within their confines.
So what you would really be saying, Your Honor, is that the legislature left out how to make a pass back and forth, the transition, and the court can judicially create the transition, and that is where you get into now you're just in a non-judiciable, political question. So that is not, again, the way the argument is being framed as to access to the records and what they need is the disconnect. Clearly, the statute, if they saw a problem, this position routinely defaults to the clerk by virtue of the fact that it's just such a small role after all the information comes in. Read what the budget officer does. He's up here arguing it's not just the budget officer stuff. Now they're talking about making decisions on a regular basis as to there's enough funding in the account. Well, guess what? The clerk also is the one that's criminally liable if a check gets written and there's not sufficient funds. So the argument that I presented orally actually is off the issue that's presented in the writ, and they're getting into the accounting function of Mr. Shipp's office versus here is just the budget office function, what this office does in terms of the budget, how it's pulled together, then promulgated in order to get to the final product of assembling it. I don't think it's apples and apples at all, and I think you're getting into a role where you're going to lose, you lost subject matter jurisdiction if you think you have to craft the remedy. Writs aren't for adjudications and findings. They're to compel a public officer to do a specific statutory or regulatory duty. We are literally sitting here arguing entitlement to a software program that they're not named in the contract, that although they're talking intent, they never brought a deck action within 5 years of that contract being signed. You can't go in now and look at it. The statute of limitations has run. And again, there's no grounds for a writ, an extraordinary remedy. If this is the case, we can bring writs to whenever they want to look at anybody else's records for whatever reason. It's really a floodgate of what's being argued. It is a complicated issue, the different roles of the clerk, and again, it's a complicated position, but he conceded on the record, and I think that's where he did it. It's an arbitrary exercising of judgment as to who and how. That's his view. The court's view is it's called safeguarding and maintaining the accuracy and veracity of the records that he has to certify to the Department of Financial Affairs. And these records go up on a monthly basis. There are so many other places that these records exist that it kind of begs the question of access and why this is so important. This seems like a civil deck action that needs to come first. So again, I don't think when the motion was written by Mr. Griffiths, he meant administrative. The cases that were cited were talking about different administrative remedies. It's have you exhausted, is there no other judicial remedy for you? And here they clearly obviously need to bring a lawsuit regarding entitlement if they think they're entitled, so the court can do that, make findings, discovery, and start taking some depositions. This is not what you do in a writ. So that's why the positions, I can hear the arguments, there does appear to be another cause of action. So he defeats his grounds for a writ by the way he's framed it. And you, again, have lost jurisdiction if you believe that you can craft a remedy to take up the legislative gap as to providing, right, as to, no, I'm not saying, I'm just saying that, but you look at it, you're trying to...
The court's not suggesting that the court's going to do so. I'm suggesting that they have already presented argument that there's not a legislative gap, that you have to read it together to give meaning to the entire purpose. They
haven't provided a single statute that shows that. They've argued some cases regarding...
Gotcha.
Yeah, they've argued some cases where they're doing self-serving resolutions and then saying, we want that. That is not... That doesn't, they can't prescribe the duty onto my client. The statutes of the regulatory scheme has to provide the duty. They have not cited a single statute that he's in violation of. That's the problem.
I appreciate both counsel laying out the respective arguments. It's going to take me a little time to review what's been presented today. I have already reviewed each of the cases that are presented to the court, but I want to produce in writing and order on this matter as soon as the court can. And I don't want to give you a deadline, but obviously I am cognizant of the need for a rule for us to move further. So it will be as soon as the court can do so. I will get that out to you within the portal. It will be issued to you